Testing 1 2. Testing 1 2. Hey Siri, stop. Testing 1 2. Testing 1 2. All right, that's done. All right, what's up, ladies and gentlemen, and welcome back to the Supreme Decisions. Hell, visual podcast for the most part, but right now. Anyway, today we're going to dive into one of the most controversial and misunderstood concepts in criminal procedures. Yes, I'm talking about procedures today, people. And this is also one where I constantly tell people when you're representing your own interests and you get discovery, pay attention to timestamps. Why? Because that's when you understand where power lies. And that's why we have today's video. After the fact warrants. And can they be backdated? Is that allowed? Well, the so-called after fact warrant, I want you to imagine this. Law enforcement enters your home, seizes evidence, and only later goes to a judge to clean it up with paperwork. Sounds very unconstitutional. But the truth is, courts across the country have wrestled with the legality of retroactive warrants for decades. I want you to pay attention to that. They've wrestled with it, which means, how about I finish this? Go ahead and get some nourishment from this food that I'm giving you. Okay, at the heart of the issue lies the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and etc. against unreasonable searches and seizures, which shall not be violated, and no warrant shall issue but upon probable cause. The framers wrote this to prevent the government from introducing or intruding first and justifying later. Now, yet in practice, law enforcement sometimes seeks judicial approval after the fact. And this is why I came up with this, because I heard a police officer say this literally today. And sometimes when the exigent circumstances are occurring, because again, you got to act right now during exigent circumstances. That's where the wrestling starts. Or when evidence has already been seized. The Supreme Court has ruled on elements of this doctrine. Congress has litigated exceptions through statutes like the U.S. Patriot Act and Title III wiretap laws. And defense attorneys and pro se litigants like myself have fought tooth and nail to challenge these shortcuts. Now, here's where the fun begins. It's understanding how to challenge it, because today we're going to talk about what after the fact warrant is. Is it legal? How does it warp the constitutional framework that defines a valid search warrant? And buckle in. We're about to tear into law, the loopholes, and the lessons. Because even whenever I was charged, one of the first headings was found legal loophole that allowed. And I was like, then that means it was legal. Because if a loophole allows, that makes it legal. You about to love me for this one. Now, defining the after the fact warrant. The concept is the warrant issued by a judge after the fact the government has already conducted a search, seizure, or surveillance. Now, I'm going to give you a couple examples. Wiretaps approved retroactively under Title III, which is 18 U.S.C. 2518. Now, the Foreign Intelligence Surveillance Act. Provisions allow emergency surveillance and judicial approval sought within 72 hours. Because again, you need approval to actually use it. And seizures where police claim exigency but later obtain warrants to cover themselves. That's again exigent circumstances. Things such as, which is one of the greatest, something is thrown out a window. You have multiple officers following. One now stops, gets out, sections off or tapes off that area, and now secures the scene while the other one continues pursuit. That is how it's supposed to be done. Now, the one that's free has the right and ability to go and obtain the warrant legally within the time frame. But that's not always what happens. But again, that's something that you tear apart in court. And now, I'm going to give you a legal terminology. Some calls retroactive warrants, or as this one suggests, after the fact warrants. In other words, backdating, covering your butt. And what happens is you now challenge this using Supreme Court cases. You're going to use Cat v. U.S. It's a 1967 case. Set the foundation for requiring warrants for electronic surveillance. Let me get a little sip. That's Arizona. Excuse me. Yeah, that's Arizona. Berger v. New York, 1967. Emphasized strict warrant requirements to prevent general searches. United States versus United States District Court, 1972. Reaffirmed that prior judicial approval is the normal. Hear what I'm saying? This is why you challenge everything, because the law is on your side because they don't do it correctly. They've even created names for their incorrect behavior. And Missouri v. McNeely, oh, that's a case I've actually spoken about. Rejected blanket exceptions for exigency in blood draws. Why did I talk about that one? Because there was a police officer who decided that he was going to take the blood from a suspect who did not give consent, who was not unconscious, basically outside the guidelines of what the hospital was allowed to do, outside the guidelines of what he's allowed to do lawfully, and outside the guidelines of actual rights, period. Everything he did was illegal, to the point he arrested the nurse who refused. The nurse refused, he arrested her. That officer kept his job, but the city was out $600,000. And the suspect that he wanted the blood from, they had to drop his case. All because this officer admittedly did not know law and allowed his ego to get in the way. Missouri v. McNeely. The rejection of exigent circumstances if the patient is awoke and can make a conscious decision, which he did by revoking the consent for a blood test. Now, most people think they're just Supreme Court issues. Now, FISA, F-I-S-A, is 50 U.S.C. 1805 F. Allows emergency surveillance with approval obtained later. I want to see if you're catching on to where these after the facts are coming from, where they are allotted to. Notice it's not allotted to police. It's allotted to federal agencies that are watching in other aspects of life, not everyday policing. The Patriot Act. Extended emergency surveillance with retroactive approval windows, which is why I'm going to give you a little peek behind the curtain. One of the things that they attempted to use against me, which I thought was amazing, and it was something that was that was caught. Someone converting to Islam or becoming Muslim allows them to get an after the fact warrant and continue surveillance on you with unlimited windows. A change of religion to Islam or becoming Muslim. Notice, most people that understand what I'm saying knows I'm saying one thing, but they're categorizing it as two separate issues, because they look at it as two separate types of organizations. And countries traveled to. Always understand that. They think it's simple. You think it's simple. It's everyday, some normal stuff. You're going on vacation. That's not how it's being addressed when you're involved in this level of surveillance. Wiretap Act requires application for retrojudicial approval within a short time frame. Notice again, all of these are federal agencies: CIA, FBI, NSA, a whole bunch of ABCs, all them. These laws that don't deal in everyday policing. And it's for surveillance, not searching and seizing, which police attempt to use. Now, the bottom line is, it's legal only if a statute explicitly authorizes retroactive approval. Notice I did not read one that dealt with searches or seizures. Notice I didn't read one that allotted an approval for a search or a seizure. And without it, it violates the Fourth Amendment. Now, here's the great part about it, because I've given you this, the impacts of what makes a valid warrant. I've given you this one at least 5 times. 5 different videos, I think 2 or 3 podcasts where I speak about the validity of a warrant, what makes it valid. Probable cause, Illinois v. Gates. Neutral and detached magistrate, Coolidge v. New Hampshire. Specificity or particularity of place and items or person, Stanford v. Texas. Now, prior judicial authorization, Johnson v. United States in 1948, which makes it clearly established. Prior judicial authorization. Now, most people think it's simple. Just have a neutral judge sign up. Prior. Note where I went with that. This is for everyday policing. And after the fact warrants undermines element number 4, the prior aspect of it. These are the things that I talk about. This is why you challenge. The warrant was not done in a timely fashion. Hence, the fruit of the poisonous tree. Hence, remember the conversation I had with a police officer. I hope you find something, because I've never given consent. Because if you find anything, you now have to get the specialness of what made you special, because I've never consented. Never. I'm like, what is that, Ray Charles? Never had it, never will. I'm not doing that. I don't consent to nothing. I don't authorize nothing. My favorite word is no. In fact, 90% of the time, whenever how you doing today? Can I have your license? No. That is literally programmed into my, I don't care what you have. My son has to ask me things 2 or 3 times, because my first answer to him is no. Dad, can I? Nope. Why you said no? You didn't even hear what I said. I don't need to hear, because I know you're getting ready to ask me something crazy. No. Can I have your license? No. Can I search your car? No. Am I hired? No. That is literally my favorite word. I'm not going to just consent just because. Especially when I know someone wearing a uniform is my employee. And I'm going to treat you as such. I don't ask my employees to do their job. You either do them or you're fired. And this is how I understand this. So when we're talking about an after the fact warrant, that's used in everyday policing, it is illegal and a violation of the Fourth Amendment, which now you got to tap those pockets because it's clearly established. This case was before most of us was even thought about or even considered to be born, because it converts judicial approval from a gatekeeper function to a rubber stamp function, which then defense attorneys or pro se litigants can challenge such warrants as fundamentally unconstitutional unless Congress has carved out a narrow statutory window. Outside of exigent circumstances, that warrant is invalid. It is invalid because, again, the time stamp. You were arrested at this time, they searched at that time, that warrant was stamped the next day. Everything that was found is illegal. Remember I showed you the video with the police officer chasing the man into the house and the gun goes under the couch. Cop immediately goes under the couch, grabs the gun, and the gun was thrown out. And he goes, well, why? He said, because you had time to secure the room and get a warrant. You had the suspect in custody. You had him away from the couch. Clear the room, secure the scene, get a warrant. Why? Because they don't know what probable cause is. And I could say that until I'm blue in the face, which actually ain't that darn far because I'm pretty dark. But at the end of the day, that's the law. That's not me. And just like you're hearing now and seeing now, we're putting everything together that I've been speaking about for the past 7 years. And I'm gonna give two people shouts out because I appreciate. Twin has been hitting damn near every live, and I appreciate you, brother. And one of the Copelands, appreciate you joining in. Now, here's one of the, give you a couple scenarios. If a DEA conducts a warrantless wiretap during an urgent cartel operation, the judge approves it 3 days later. You file a suppression motion. Court upholds a Title III emergency provision. Notice, if you're dealing with the cartel, you're dealing with a quote-unquote terrorist. That's what they've been labeled as lately, terrorist. So even, it doesn't matter what the first, DEA, ABC, FBI, CIA, all of them have the same provisions. And those are, and the main use would be Title III, Emergency Provision Act, because the level of threat. And that's not everyday policing. Police break into an apartment without exigency. Later obtain a warrant. Suppression is likely granted because of post hoc approval is not authorized. I'm going to say that one more time. Police come in your apartment without a warrant. You file a motion for suppression. This is the challenge because post search and seizure approval is not authorized, even if the judge signs off on it, because the timestamp. They need prior judicial approval before they do anything, because you can't let children run ransack. Remember again, Jordan v. City of New England. Jordan v. City of New England. Mind of a child. Malloy v. Hogan. They don't know what probable cause is, which is why they have to go get a warrant. So doing it after the fact is a violation because there are steps to getting that warrant. They need probable cause and they don't know what it is. They're using stock language. They can't even speak the truth because they can't articulate. Notice all these things that we keep seeing as daily and just the simplicity of it. A lot of people ask, why do you do it that way? And it's because it's easily digestible. So now when you're hearing it again and it's all being put together, you're like, oh, I wouldn't have been able to eat that cake at all at once. Because yes, I can put it out there in the effect of it being something that you don't like, but at the end of the day, it does not change the effect of what it is. That's why I keep saying it. Because at the end of the day, the whole point of this is to make sure you understand how to defend yourself. And if you're not savvy enough to understand the nuances of it, you get someone else to do it for you. Because you're either going to pay with time, or you're going to pay with money, or you're going to pay with both. Get you an out-of-town shooter. Someone that's not part of their team that can keep you in your most powerful state. And make sure that the person that's working with you isn't working for them. Now, I'm going to give you the last one. National Security Surveillance, FISA. Evidence obtained may be admissible if statutory compliance was met, even though the warrant came after the action began. Why? NSA. Again, not everyday policing. And I can say this because I keep telling everybody, because just like the young man said something to me the other day. He was like, well, you didn't go to school. Didn't know that you could only be able to read in school. I didn't know that you could only apply what you're reading if you went to school. I didn't know that the ability to read and apply can only be done together if you went to school. Because the problem is, my school was never a building. The fact that I was able to learn this, go and watch it and duplicate what I'm doing, and then become a monster at this. I'm learning how to master this, because even this, some of the things I'm doing now, I'm able to apply them faster, and I'm seeing nuances and seeing shifts in real time. Because it's amazing at how now I can look at something and I can start telling the story before I hear it. And even with, let's say, a complex issue. Uh-oh, why is it lagging? It should not lag. I got 5 gigabytes going through. Take it off 4K. Let's see if that works. Yeah, put it on 1080. It should work. Now, one of your actual strategies is attack the timeline. Make sure you're checking timestamps. Was warrant sought immediately or after a reasonable delay? Now, understand the words reasonable delay. Remember, we talked about the 15 minutes. We also talked about sectioning off certain things because of possible destruction. Now, to attack the statutory compliance. Did law enforcement meet every technical requirement? They're not going to meet 4 if it's not stamped properly. And attack probable cause retroactively. Again, that timestamp. Was the probable cause established before the action or manufactured after the search? And manufacturing is what they'll do. Now, the alternative perspective. Prosecution will view a retroactive warrant to allow flexibility in emergencies. They will attempt to create an emergency when there is none. That's why I spoke about whenever you're doing what do you call that? I just went blank right then. I literally just went blank. Oh my God, that was crazy. I just went completely blank right there. They're going to create an emergency even when you're not. Now, one of the things that I spoke about before was if you're handcuffed and you're not in arm's reach of the vehicle, they cannot use that as exigent circumstances to search the vehicle. Why? Because there's no possible way to destroy evidence. Because one, you're secured with the officer, hands are behind your back, you're more than 8 feet away from the vehicle. Can't destroy anything. They must get a warrant. And if they don't, there is no reasonableness, nor is there an emergency. This is what you attack. Now, here's the great part about it. I want you to understand something. Because I actually had somebody get upset, I want to say about a week ago. We went and attacked we did the suppression, went in the hearing. The judge, boom, let's call it a gun. I don't remember exactly what it was, but he said the gun stays in. So the guy's upset. He's 38 hot. I told him, I said, go get a copy of the signed disposition. He was like, man, I don't know. I said, just do it. It's a formality. So he goes. They give him a copy of what was written. It wasn't signed. He goes back because he just sends it to me. I say, hey, it's not signed. So he goes back. Finds the judge. It actually finds, hey, I need a copy of this one signed. Judge tell him, oh, the clerk should have it. He said, well, the clerk told me that you hadn't signed it yet. So I have a copy that you can sign now. Just go ahead and file it. The judge said, well, oh, you have to get it from somewhere else. So he calls me because he's confused now. The judge banged his gavel and everything. Why didn't he want to sign it? I said, because if he signs it, that's getting turned over on appeal simply because there was no reason for him to not suppress the gun. Because when he signs it, he has to now put his name on it because he has to stand by his decision. If you accept it without the signature, you've accepted that the gun is in, and most people will not pay attention to that because that's why you're looking at these warrants, because that's also prior judicial notice. He can bang that gavel, but he's also got to stand by those words. And if he chooses not to, it's up to you if you're going to accept him. Because had he not done that, had he accepted it just because he heard it, he wouldn't be able to bring it up in appeal if he lost the case. Now, fast forward, Monday the case was thrown out. Why? Because the judge couldn't stand on that, because keeping that case going with an invalid warrant leaves the judge open to liability. And he understood where I was walking into. These judges play chess all the time. And a lot of times, I tell you, this is psychological. If they can break you, they will. Because it's about revenue, not about law. So when you're pressing them with the correct law, the correct verbiage, and the correct process, there is nothing they can do about it. This is, and I hate to say this too, and then I'm going to start wrapping this up. This is what separates me from everybody else that supposedly do what I'm doing. They will tell you something or they'll sell you something. I'm going to say that one more time because I want to make sure you hear me. They're going to tell you something or they're going to sell you something. But they can't explain how it's able to apply, and they don't understand the process on the level that I do. It is a beautiful thing. You know what, damn that, I do brag about it because I am in a class by myself. This is, somebody asks me, what do you worry about those people? No, they don't do what I do. And very few people do it at the level I do it. Because when I'm doing this, it's like threading the needle with your eyes closed. I've been doing this long enough to understand what every piece does and their responses. Very few responses surprise me. Because even if it does, I want you to understand something. It only can go to a couple places. It can only go a couple ways. Because every piece has a definitive move. And I understand that. And even when we're talking about this, right? When we're talking about the civil liberties view of the after the fact warrants in everyday policing, it is a Fourth Amendment violation. The civil liberties view of this also, they gut the Fourth Amendment's core protection. This is an egregious constitutional violation. This is why you can then apply it to the officer, apply it to the police department, apply it to the judge that signed it, apply it to the district attorney. You can apply it to whatever state it is. Because I've done this. I'm not just talking. I've done this. Because an after the fact warrant is the most egregious violation that you can have. Because if you notice, when it's allowed, it's for someone that is not under the protection of the United States Constitution. Uh-oh. Uh-oh. I'm going to say that one more time. When it's allowed, it's for someone that is not under the protection of the United States Constitution. So any other action with it is illegal and an egregious violation, which you can be heavily compensated for. I'm not just talking, I've done it. So now, when we're talking about the judicial view of this, courts often balance national security over public safety. I want you to understand what I'm saying. Courts often balance national security over public safety and the basic instinct of individual rights. Now, have there been inconsistent rulings? It's because there have been inconsistent challenges. Because most people don't understand to challenge what aspect of the warrant. Because I've actually seen a few where they were the attorneys, the district attorneys, or I'm not district attorney, but the defense attorney, they were kind of befuddled because they filed it, but they used it wrong. Because just like I tell you, you have all the pieces to the game, just don't know how to play it. You can't see where the moves are going. And it's almost like now, because I'm home more and I have in essence more free time. I have more me time, more think time. A lot of this is, hell, I'm playing speed chess now. Because I'll look at something, okay, boom. Now, it's very seldom do I get something that makes me sit down and dig deep. And in the context of doing that, it makes me sharper because now I have to learn something new. And that's the challenge for me. Learning something new and not being repetitious. Because a lot of the stuff that I'm saying to you guys in the last couple of weeks are things that you may have heard in passing and have very little idea what it is or how it works and how it's being used against you. This is what I'm here for because, again, I've done this, and to me, it's commonplace. But I don't use the words after the fact warrant. I speak about timestamps. And if you go back and listen to my video, you listen to the podcast, that's what I'm referring to. An after the fact warrant. When I'm using the words timestamp. And most people will never get it because I'm not speaking a language that they're readily accepting in their mind because it's not something they often hear, and they think that it's something that has no effect. That's the one thing that gets to everybody, is the understanding of what it is they're doing and how they're doing it. God dang, I was like, what is that? That I'm in the desert and it is thundering out there. That thing is cracking. Anyway, let me wrap this up because I got a couple more videos I'm going to be back on here later on today, literally within the next couple hours. So, where does this leave us? The after fact warrant is not a blanket tool in government arsenal. It is narrow, statute driven, and is only offered in certain exceptions, which is not everyday policing. Outside the specific laws like FSA or Title III, courts have been crystal clear. Judicial approval must come before intrusion, not after. And if it comes after, that is a violation. And here's the great part about it, because I actually spoke about this young lady when I talked about negative retention. I can't remember her name, but she's done this multiple times. She is a bad cop. So go look at the video, Negative Retention. Go listen to the podcast, because I mentioned her name several times. She still works for Richmond County. I still had a couple of people that actually came in and told me how bad of a job she was doing, and she was still doing the same thing. And understand, these are the challenges that you can come up with, because you have at least 2 instances in which she's done something egregious against the Constitution, egregious against her oath, and her lying and not being honest or trustworthy. At least 2 of them. 3 takes a pattern, but I guarantee you, if she denies any of this, you can go into her personnel history. And pull out. You're probably not going to have to go more than 2 or 3 cases, because she's that bad of a cop. But here's the next part. By them keeping her employed, they want her there. They don't care that she's a bad cop, because she's generating revenue for them. That's what bad cops are there for. That's why they escalate. That's why they do the things they're doing. That's why they're promoted. Because just like Christopher Donner, oh, he was a killer cop, but you forget about Teresa Evans, who kicked a man who was having a medical episode that was handcuffed. She got promoted. Christopher Donner got fired. How is that good? Because Christopher Donner was the one who reported her for kicking a handcuffed man in the head while he was having a medical issue. They want bad cops there. This is our fight back against them, because the law is something they don't know. Jordan v. City of New England. And as for either defense attorneys or pro se litigants, our job is to remind the judges that the 4th Amendment was written to prevent the very abuse after the fact warrants invites. Government intrusion justified by hindsight. We fight these cases by attacking probable cause, because they don't know what it is. By questioning timelines, because we're watching the timestamps. And by hammering home that constitutional rights are not optional. The paperwork must be filled out prior to. So next time you hear about evidence approved after the fact, know this. It sounds legal, but it's a house of straws. It's on shaky ground. There is nothing foundational about it, and it is trash. So next time, remember, justice delayed is justice denied, and a warrant delayed may not be a warrant at all. This is Supreme Decision. That is my 2 cents. Spend it how you like, and I'm out.